Not everyone agrees a mere arrest should get your DNA added to the state database.
But I'm not sure, and I'm saying this because I don't know all the particulars in reference to the case, that sometimes the system might leave some cases of abuse of the system itself by allowing that.
Becky Da Cruz, a criminal justice professor at AASU, says there are several areas in which the law might be challenged: the Fourth Amendment against search and seizure, and the Fifth, your protection against self-incrimination. But based on past cases, she doesn't believe either argument would stand up in court.
The Supreme Court has said that any kind of fingerprinting or other information about you that could identify you in a crime is permitted to be taken by the police. So if seen along the same lines as fingerprinting, it's going to suffice under the Fifth Amendment. It really is a search incident to an arrest, and so those are seen as permissible as well by the courts.
What could pose a problem is the money to pay for it. District Attorney Larry Chisholm says the GBI currently has a backlog of around 5,000 DNA samples to process. Opening the floodgates would only make that problem worse. But he says if the state is willing to bear the expense, the effort would be worth it in the long run.
I think that it opens up the investigative avenues that police and law enforcement will have in terms of solving some of the unsolved crimes, and particularly in the more serious cases like rape and murder. Oftentimes you'll have a body down or you'll have a victim, but you won't have a suspect, and this really empowers law enforcement to have a larger pool to examine.
Sheila Parker, WSAV News 3.